But here we have some problems too, because it's kind of difficult to apply. And this really is a broad definition of insanity. So theoretically, this would exonerate a lot more people than before. And what does mental disease or defect really mean? I mean, who is to determine that? Does that only mean mental illness as defined by the Diagnostic and Statistical Manual? Or can a psychologist just say that this is the result of mental disease or defect? So how do we know what it is? Durham or the product test wasn't perfect either. Then in 1962, the American Law Institute came up with a standard for how a defendant would be found not guilty by reason of insanity, or criminally responsible, or not responsible as a result of mental illness. So the ALI standard stated, as a result of mental disease or defect, he or she lacks substantial capacity either to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law. And they call that like the model penal code for insanity. And to me, this is very similar to McNaughton with the irresistible impulse test. So substantial capacity to appreciate the criminality of his conduct, to appreciate whether it's right or wrong, or to conform his conduct to the requirements of the law. That's like the irresistible impulse. But here, it's because of mental disease or defect, you lack the substantial capacity to do either of those. So is this a fix? Was the ALI standard good? Well, it was okay, but there were some problems with this too. So this excluded defendants whose mental illness or defects only manifested themselves in criminal or antisocial conduct. So we had a problem. What if, like, for example, we had a serial killer whose only symptom of mental illness is killing their victims? So does that mean that that individual should be found not guilty by reason of insanity? Oh, I don't know. I don't think so. So what is substantial capacity? This is the mental capacity needed to understand the wrongfulness of an act or to conform behavior to the law. So think about that. Then we had the case of Hinckley. So Hinckley tried to shoot President Reagan, and a Secret Service agent and a Washington police officer were also shot, and so was Reagan's press secretary, or James Brady. You might have heard the Brady Bill. That comes from this. Unfortunately, Brady was killed. Hinckley claimed that he was trying to impress Jodie Foster, which you may or may not have known. Now, Jodie Foster, in her own right, is very important to the field of forensic psychology. So, as a side note, Jodie Foster won't talk about this case. I think it really scared her, obviously, but she's gone on to play some of the great characters in movies that are related to forensic psychology, and I have to speculate that this has something to do with it. So Hinckley was infatuated with Jodie Foster. He was obsessed with her. Alright, this is Hinckley right here, and that's actually him posing in front of the White House. I think he had a pretty good idea as to what he was going to be doing in the future. Now, he was obsessed with Jodie Foster, and I'm going to read you one of the love letters that he wrote to Jodie, which is pretty scary. But he used the insanity defense. So obviously, after his horrific crimes, he faced trial, and he was found not guilty by reason of insanity. And in the past couple of years, every once in a while, just maybe a month ago, I saw an article in a tabloid that Nancy Reagan was fearing his release. He has gone to a state mental hospital or a forensic hospital, and once he's found not to be dangerous or mentally ill, then he theoretically should be released. And he has been released for visits. He's gone on extended visits even, and he might someday be let free, even though he tried to kill the president. So here's a letter that he wrote. I'm just going to read this out loud. It says, "Dear Jody, there is a definite possibility that I will be killed in my attempt to get Reagan. It is for this very reason that I am writing you this letter now. As you well know by now, I love you very much. Over the past 7 months, I've left you dozens of poems, letters, and love messages in the faint hope that you could develop an intense interest in me. Although we've talked on the phone a couple of times, I never had the nerve to simply approach you and introduce myself. Besides my shyness, I honestly did not wish to bother you with my constant presence. I know the many messages left at your door and in your mailbox were a nuisance, but I felt that it was the most painless way for me to express my love for you. I feel very good about the fact that you at least know my name and how I feel about you, and by hanging around your dormitory, I've come to realize that I'm the topic of more than a little conversation, however full of ridicule it might be. At least you know that I'll always love you. Jody, I would abandon the idea of getting Reagan in a second if I could only win your heart and live out the rest of my life with you, whether it be in total obscurity or whatever. I will admit to you that the reason I'm going ahead with this attempt now is because I cannot wait any longer to impress you. I've got to do something now to make you understand in no uncertain terms that I'm doing all of this for your sake. By sacrificing my freedom and possibly my life, I hope to change your mind about me. This letter is being written only an hour before I leave for the Hilton Hotel. Jody, I'm asking you please look into your heart and at least give me a chance with this historic deed to gain your love and respect. I love you forever, John W. Hinckley." Every time I read that, I just kind of freak out inside. I can't believe he wrote that. And can you imagine being Jodie Foster getting this letter? She was a college student at Yale, and I know girls in the class have had trouble with stalkers before, and maybe have gotten some weird love letters. What if you got a letter like this that said he was going to go get Reagan? He was on his way. This is terrifying, and I feel really bad for Jodie Foster. But this gives you some really good insight as to the mind of this individual. So, according to Hinckley, he said that this was the greatest love offering in the history of the world. At one time, Miss Foster was a star, and I was the insignificant fan. Now, everything has changed. I am Napoleon, and she is Josephine. I am Romeo, and she is Juliet. You can see that Hinckley isn't thinking very clearly about this horrific crime. So, after Hinckley, the public was outraged. The legislature was out. Everybody was outraged in the country. So this led to the Insanity Defense Reform Act of 1984. And the federal insanity defense now requires the defendant to prove by clear and convincing evidence, and we'll talk about what that exactly means, that at the time of the commission of the acts constituting the offense, the defendant, as a result of a severe mental disease or defect, was unable to appreciate the nature and quality or the wrongfulness of his acts. Now, to me, this kind of sounds familiar. And what I think this is, and all the critics say so, is that this is a full circle return to just knowing right from wrong. So we've had this evolution and de-evolution and narrowing and broadening of the insanity defense, and I'm sure things will change and change and change. And not all states agree on their rules of the insanity defense. Some states have gotten rid of it completely. So, Again, I imagine that we'll have cases in the future that will have a big impact on this. Now, the Jared Lee Lochner case, it would be a good one to keep an eye on. He won't be facing trial quite yet, but when he does, I'm sure he'll enter a not guilty by reason of insanity plea. Now, Lochner won't face trial right now. And why is that? Well, that's because of an issue of competency. And competency is something very different from not guilty by reason of insanity, and you need to differentiate between the two of them. Competency has nothing to do with guilt or innocence at all. And I ask those questions habitually on midterm exams and final exams, and students get it wrong all the time. So competency refers to your mental state now. The insanity defense refers to your mental state at the time of the act. So competency refers to a person's ability to understand the nature and purpose of court proceedings. And this is applicable at every stage of the criminal justice process, right from arrest and interrogations to pretrial hearings and even sentencing. So this has an impact on guilty pleas, the ability to even stand trial, or even a death penalty. So you actually have to be competent in order to be executed. So it's really fascinating. You have to understand the nature and purpose of the court proceedings, and you have to assist in your defense. And Jared Lee Lochner probably can't do that. So what happens to somebody that's found incompetent? Do they just throw the trial out? No. They go to a state forensic hospital or a state mental hospital, and they are restored to competency. Now, there's no federal guidelines or state rules for determining competency. Now, oftentimes a forensic psychologist will do competency evaluations. And in some cases, competency has been described, and these are not my words, as the ability to know the difference between a judge and a grapefruit. So in some jurisdictions, competency is pretty loose. And nobody really has defined competency, so that's an interesting dilemma. Now, all jurisdictions require that a defendant be competent to stand trial. And again, they understand the nature of the proceedings against them and are able to assist in their defense. A person who is found to be mentally incompetent to stand trial, this is always a question that I ask students, and they get wrong. They're usually hospitalized for treatment until such a time that that person is in fact competent to stand trial, and then they go through with the trial process. And then the last one here, again, I'll repeat this again. Competency does not address the guilt or innocence of the individual whatsoever. And so do not confuse competency with the insanity defense. Malingering is an interesting issue, and malingering is a fancy term for lying, or the conscious fabrication or gross exaggeration of physical and or psychological symptoms done in order to achieve external goals such as avoiding prison or receiving monetary compensation. So forensic psychologists will oftentimes do evaluations and will evaluate for malingering, and we have a number of tools that we use to detect malingering.